Companies Act, Section 282, Directions of Tribunal on Report of the Company Liquidator. Section 282 of the Companies Act, 2013 empowers the National Company Law Tribunal, NCLT, to issue directions and make necessary decisions based on the report submitted by the company liquidator during the course of a company's winding up proceedings. This section outlines the tribunal's role in monitoring, controlling, and directing the liquidation process, ensuring that it is carried out efficiently, transparently, and in the best interest of stakeholders. 1. Tribunal to fix time limit for completion of proceedings and dissolution of the company. Upon examining the report submitted by the company liquidator, the tribunal is required to determine and fix a specific time frame within which the entire winding up proceedings must be completed, and the company should be formally dissolved. This provision ensures that liquidation does not become an unnecessarily prolonged process and that there is a clear, time-bound roadmap for the completion of proceedings. Power to revise time limit. The tribunal also has the power to revise the previously fixed time limit under certain circumstances. Specifically, if, at any stage of the proceedings, or upon further review of any subsequent reports filed by the company liquidator, and after hearing from the company liquidator, creditors, contributors, or any other interested party, the tribunal is of the opinion that continuing the liquidation process is no longer advantageous or economical, it may revise the earlier timeline. This helps ensure flexibility and efficiency in handling cases where early closure is deemed more practical. 2. Tribunal's power to order sale of company or its assets. After reviewing the liquidator's report and hearing interested stakeholders, the tribunal may issue an order for the sale of the entire company as a going concern, or the sale of its assets or any part thereof, depending on what is considered in the best interest of creditors and stakeholders. This provision allows the tribunal to take proactive steps to maximize the value of the company's assets and potentially preserve its business operations, if feasible. Appointment of a sale committee. In furtherance of such a sale, the tribunal is also empowered to constitute a sale committee to assist the company liquidator in executing the sale. This committee may consist of creditors, promoters, and officers of the company, as the tribunal may deem appropriate. The involvement of multiple stakeholders in the committee helps ensure transparency, accountability, and representation of diverse interests in the sale process. 3. Action in cases involving fraud. If the tribunal receives a report from the company liquidator, the central government, or any other person, alleging that fraud has been committed in respect of the company or its affairs, the tribunal is required to take the following steps. Investigation under Section 210. The tribunal shall, without hindering the winding up process, order an investigation into the affairs of the company under Section 210 of the Act. Post-investigation actions. After the investigation report is submitted, the tribunal may pass appropriate orders or issue directions under Sections 339 to 342, which deal with personal liability for fraudulent conduct of business. Power to assess damages against delinquent directors or officers. Prosecution of individuals for misconduct. Additionally, the tribunal may also instruct the company liquidator to file a criminal complaint against those involved in committing fraud, thereby ensuring that culpable individuals are held accountable under criminal law. This provision reinforces the tribunal's commitment to upholding justice and deterring corporate fraud during liquidation. 4. Protection and enhancement of asset value. The tribunal may also, either on its own or based on reports or representations made during proceedings, issue orders to take necessary steps and measures to protect, preserve, or enhance the value of the company's assets. Such orders may include preventing asset dissipation, improving recoverable value, or maintaining operational integrity until sale or distribution. The intent is to safeguard the economic value for the benefit of creditors and other stakeholders. 5. Residual powers of the tribunal. In addition to the specific directions enumerated above, the tribunal is also empowered to pass such other orders or give such further directions as it deems fit in the circumstances of the case. This clause serves as a residual or enabling provision, giving the tribunal wide discretion to act in the best interest of justice, even where the statute may not expressly provide for a particular scenario. For more details, contact us.